everyone and welcome to InnoEnergy's Intellectual Property channel. We are the IP team, and as you might know, patenting is of vital importance, but not everyone can file for a patent, and better yet, not everyone should. So this webinar will be designed to discuss the questions that you need to ask yourself to know if patenting is valuable for you. And we will also discuss the criteria for patentability, thus addressing if an invention can be patented or not. And we will do so by introducing the concepts of novelty and inventive step. So how do you know if filing for a patent is beneficial for you? So as you might know, applying for a patent can be time-consuming and expensive. But if you get a patent, it can provide significant protection for your invention, and it could even become a valuable commodity that can be sold. But this doesn't mean that everyone should patent. And one of the first questions that you need to ask yourself is if you will make any profit in the future, or if a patent is commercially viable. As I said, a patent can be quite expensive. So if you know for certain that you won't make any profit on the invention that you want to patent, you might want to reconsider patenting. And the profit can either be from going to the market yourself with the invention, but you can also, of course, sell the patent. So second of all, you should consider keeping your invention a secret instead of patenting. And secrecy can be a great option to protect an invention. However, you need to make sure that it cannot be reverse engineered once on the market. So for example, if you invent a new solar cell, which can easily be reverse engineered by others, once you start selling them on the market, it is recommended to get a patent. And you must also think about the market situation. If you keep information a secret and someone else comes up with the same information by itself or by themselves, they are allowed to use it. So in the case of secrecy, if someone comes up with the same information, they are allowed to use it. So if you have invented something which a lot of people are working on, a patent might be recommended, as they might come up with the same information by themselves in a later stadium in time. However, to get a patent, you must really be the first one to have come up with this idea. Otherwise, it's not new and therefore not patentable. We will discuss this later a little bit further. And early patenting is always recommended to make sure that others don't beat you to it. However, you must always consider as well that it might not be the right time to patent, and you should ask yourself if it's the right time to patent. For example, if you're still working on a prototype that can change significantly, it might not be handy to base a patent on how the prototype works. It might be more beneficial here to wait until the actual invention is finished. So once you decide to patent, you must also make sure that you can patent. And the patent law usually requires that for an invention to be patentable, it must be new, non-obvious or inventive, and useful or industrially applicable. So first of all, you can only file for a patent if your invention is new or novel. This means that the invention should not have been publicly disclosed before your first application date. So no one must have invented this exact same thing as you before at the time that you file for a patent. And everything that has been publicly available before your patent can be used to undermine the novelty of your invention. And this is called prior art or background art. For example, a picture, another patent, a PowerPoint presentation, a film, a still display, and an invention demonstration, an audio file, and even speaking at a conference for a specific audience can be considered as prior art. And here it is not important if the content was actually disclosed to someone of the public. The criteria for novelty and prior art is whether someone from the public could have had access to the information without any breach of confidentiality. And what is very important to remember from this webinar is that your own disclosures, like publications, are also considered to be prior art, at least in Europe. In some countries it's a little bit different. But mostly In most countries, your own publications are also considered to be prior art. So if you want to patent in the future, it is very important that you keep your invention a secret and that you not stand in the way of your own patenting. Furthermore, for prior art to be novelty destroying, it should contain all the same information and constitute similar claims. So, for example, if patent 1 claims a process of heating from 0 till 50 degrees, and another patent claims a process of heating between 50 and 100 degrees, this is considered to be novel, as it is not exactly the same. However, it can lead to issues for inventive step, which we will discuss in the next slide. So with the criteria of novelty, one looks at the difference between two documents. And there is only an issue with novelty if the documents claim or describe exactly the same thing. With an inventive step, this is a little different. Because with an inventive step, each publication is not accessed separately, as the inventive step is considered with regard to a combination of prior art. So the inventive step principle basically says that if a combination of prior art documents is obvious to a person, an ordinary person skilled in the art, then the invention is not patentable. So very simplified, if you combine patent A about a solar panel with patent B about a battery, and you make patent C for yourself, claiming a solar panel with battery, this is not considered to be inventive, because it's just a combination of two already existing things. So all with all, the inventive step conveys the idea that it's not enough that the claimed invention is new, it must also be substantially different from what exists in the prior art, and the difference here must be the result of a creative idea, and it must be a step that is noticeable. So there must be a clearly identifiable difference between the prior art and the claimed invention. Furthermore, an invention is only patentable if it has an industrial application, or if it can be made or used in any kind of industry, including agriculture. So in this sense, abstract things cannot be patented. But also some technical areas in some countries are excluded from patentability, like software and business methods. And one of the major additional requirements of patentability is that a person skilled in the art should be able to repeat or remake the invention on the basis of the patent. So for that purpose, the invention should be disclosed in the patent in such a way that it can be reproduced. So of course, one of the essential things then is that the language in your patent is written clear and unambiguous. So a patent is only accepted if the invention is described in such a way that is reproducible. So we have now come to the end of this webinar. If you have any questions or would like to know more about patents and patentability, you can always contact us. We'll be more than happy to further advise you. And we'll also be posting more informational videos about intellectual property online soon, so be sure to watch these by following InnoEnergy's intellectual property playlist. You can contact us through LinkedIn or through our email addresses, which is frontname.lastname@innoenergy.com. And thank you very much for your attention, and hopefully I will see you again at one of our other webinars. Thank you very much.